Imagine it. A taxi, late at night. Maybe that humid stillness you get in the Northern Territory.
Yeah, quiet. Too quiet, maybe.
And then suddenly, violence. An aggravated robbery. The whole atmosphere shattered in an instant.
Calm, gone, just like that.
Police sirens, flashing lights, the usual aftermath. Suspects are identified, and that familiar machinery of justice starts to grind.
Arrests, rights, read out, the whole process kicks in.
And then comes the interview. A suspect sitting across from police, giving their account. Seems pretty routine, right?
On the surface, absolutely, just another step. But sometimes that conversation, the one captured on tape or video, it becomes something much, much more.
It stops being just a record of what was said.
Exactly. It morphs into the absolute center of a legal fight. And not because of some, dramatic confession revealed.
Yeah.
No, it's because the prosecution makes a deliberate choice not to let the jury hear that interview.
Withholding the suspect's own words. That seems counterintuitive.
It does. And that single choice, it ignites a huge battle, a real fight over fairness, over legal strategy, and over the basic duties of prosecutors.
And this wasn't just some minor skirmish in a local court.
Oh no, this went all the way, right to the High Court of Australia. And the decision they made, it seriously reshaped how criminal trials work across the country.
So welcome, everyone. We're doing a deep dive today into a really significant case. Nguyen v. the Queen, Singh v. the Queen.
And like you said, this isn't just about the robbery itself, though that was serious enough. It's about the legal maze it created.
At the heart of it all, a question that sounds simple but is incredibly complex. If a defendant gives a police interview and it's, mixed gut admissions, but also explanations, denials, things that might help them, what must the prosecutor do with that recording?
Can they just sort of cherry pick?
Yeah.
Or maybe just bury the parts that don't fit their narrative?
And the stakes here, you realize quickly, are incredibly high. This case really shines a light on the fact that the justice system involves real people.
People who might struggle with the whole process. Maybe language barriers, cultural misunderstandings, even physical difficulties. Things that make navigating the legal world really tough.
So how does the system guarantee a fair go, especially when someone's own words, spoken under the stress of a police interview, could be the key to explaining their actions?
It really forces us to look at that tension, doesn't it?
Yeah.
The prosecution's job is to prove guilt, yes, but they also have this higher duty, this role as ministers of justice. They have to ensure a fair process overall.
Above just winning the case.
That's a principle.
Absolutely. So our mission today is to really unpack this whole legal saga. We'll start with the crime itself, get the context.
And then look really closely at those police interviews. What was actually in them that made them so contentious?
We'll follow the case step by step through the courts, the procedural twists, the strategic moves.
Including who was arguing what at each stage?
Definitely. And then we get to the High Court. We'll explore the powerful arguments made there, including, really importantly, from an organization that represents disadvantaged individuals. That perspective was crucial.
And their input was vital.
And finally, we'll break down the High Court's unanimous decision. What did they actually say, and what does it mean practically for trials in Australia now, for fairness itself?
Okay, let's dive in. It's quite a story.
Right. Let's set the scene. The incident that kicked all this off was an aggravated robbery. A taxi driver, Northern Territory.
Serious stuff. Aggravated means weapons or violence or being in company. Increases the stakes significantly.
The individuals who eventually took this to the High Court were Mr. Harold James Singh and Mr. Nguyen.
And it wasn't just them involved in the original incident, right? The sources mention others.
Yeah, the Singh case names co-offenders, Davidson Vicar Clifford Campbell, Constantine Lee, and Brett James. So, a group situation.
In Mr. Singh's charge specifically.
Aggravated robbery. The details mentioned are being armed with an offensive weapon and being in company. So definitely fits that picture of group violence, potential weapon involved.
Okay, so serious incident. Police investigate. And naturally, they conduct interviews. This brings us to the record of interview, or ROI.
Can you just quickly explain what an ROI is in this context for anyone maybe less familiar?
Sure. It's basically the official recording, usually audio, often video these days, especially for serious matters of the conversation between police and someone involved, typically a suspect.
Like a formal statement, but captured directly?
Exactly. The idea is to get an accurate, reliable record of the exchange. No he said, she said later on. It's all there.
And you mentioned earlier this case hinges on a mixed record of interview, MROI. What makes it mixed?
Mixed means it's got, a mix of things in it. Some statements are against the person's interest admissions, like, yeah, I was there. Lawyers call these inculpatory. But then It also contains statements in the person's favor. Explanations, denials, justifications like, I was there, but I didn't know what they were planning. These are exculpatory or self-serving statements.
Got it. So not just a confession, not just a denial, but elements of both woven together in the same conversation.
Precisely. And how the law treats these mixed statements is key. In the NT and many other places in Australia now, they use the Uniform Evidence Law, the UEA.
And what does the UEA say about admitting these mixed interviews?
Well, Section 81 is the main bit here. It says admissions, the against interest parts, are generally admissible as evidence. That's an exception to the hearsay rule.
Yeah.
The rule against using out-of-court statements to prove something.
Right. Admissions are seen as reliable enough.
Yeah. But crucially, Section 81, subsection 2, says that related statements, including the exculpatory ones, are also admissible if they were made around the same time and if they're reasonably necessary to understand the admission.
Okay, so the law itself seems to anticipate this mix. It says you need the context, the explanation, to properly understand the admission. You can't just slice out the bad bits for the prosecution.
That's the effect of the UEA, yes. And importantly, something the High Court later emphasized, once the whole mixed statement is admitted under the UEA, those exculpatory parts, the explanations, they are evidence of the truth of what was said. The jury decides how much weight to give them, but they are evidence.
That's different from older rules, maybe.
It can be, yeah. Sometimes under common law, the exculpatory bits were treated a bit differently, maybe only showing the person's reaction at the time, not direct evidence of their truth. The UEA is clear on that point.
Okay, let's zoom in on the interviews themselves. Mr. Nguyen's interview had some particular flags raised, according to the sources.
It did. He agreed to the interview, apparently saying he wanted to clear it up. That suggests, he intended to give his side, expecting it would be heard.
But there were communication issues.
Seems so. The sources mention a specific, slightly confusing quote. When asked about using the interpreter, he apparently said something like, yeah, you ask questions, yeah. So I need to ask question and then I can answer for the interpreter.
That does sound like someone perhaps not fully grasping the standard back and forth of a formal interview through an interpreter.
It suggests a potential difficulty, certainly. Another example given was his use of no to mean yes when agreeing with a negative statement, like confirming he didn't want someone else present by saying no.
Which is a known linguistic pattern in some cultures, right? But easily misinterpreted in a formal Western legal context.
Absolutely. It points directly to those potential cultural or linguistic barriers that can really complicate things in a police interview setting.
And what about the police caution? The you have the right to remain silent part.
He received the standard caution. You don't have to speak, but if you do, it's recorded and can be used in court. The significant point noted in the sources was his stated understanding of it. He apparently said something like, whatever I answer will be taken as, will be used against you. I understand it will be.
Wow. So from his perspective, he's sitting there, possibly struggling a bit with communication, wanting to clear his name, and explicitly understanding that this whole recording, his whole story, is going to court.
That's the picture painted. It creates a really strong expectation on his part, doesn't it? And that expectation becomes central to the fairness argument later on.
Okay. What about Mr. Singh's interview? Also a mixed statement.
Yes, very much so. He admitted being in the taxi during the robbery. That's the admission, the inculpatory part.
Right.
But he immediately followed it up with a clear explanation. He said he was not part of any agreement to rob the driver, wasn't aiding or abetting the others. He was just there, but not involved in the plan.
And was this explanation plausible?
The sources describe it as contention open on the video footage, meaning other available evidence, like video, didn't directly contradict his story. It was a possible version of events.
Okay. And there was another crucial factor for Mr. Singh, wasn't there? Something about the trial itself.
Yes, critically important. Mr. Singh did not give evidence at his trial. He exercised his right to remain silent in court.
So what does that mean for his interview?
It hugely elevates the importance of that mixed record of interview. If he's not testifying, that MROI, with both the admission of presence and his explanation of non-involvement, was potentially the only way for the jury to hear his side of the story, his explanation, as actual evidence, but only if the prosecution tendered the interview.
Okay, so the stage is set. We have the crime, these mixed interviews which are admissible under the law, and clear indications in Mr. Nguyen's case of communication difficulties and an expectation his words would be used. Let's follow the procedural trail now. How did this play out in court?
Right, this is where the strategy really comes into focus. Mr. Singh actually went to trial. before Mr. Nguyen on this charge. He had a first trial.
And what happened with the interview evidence in that first trial?
Interestingly, the prosecution did tender the MROI in that first trial. They played the recording for the jury as part of their case.
And the outcome?
A hung jury. The jury couldn't reach a unanimous verdict, so the trial was aborted and a retrial was necessary.
Okay. Interview played, hung jury. Now fast forward to the preparations for the second trial, where the issue would affect both Mr. Singh and Mr. Nguyen. What changed?
A major strategic shift by the prosecution. As the second trial loomed, the prosecutor formally told the trial judge, "This time, the Crown will not be tendering the recorded interview."
Wow. After using it the first time. Why the change? Did they give a reason?
They did, and they were remarkably frank about it. According to the sources, in Mr. Singh's case, the prosecutor told the judge, quote, "To be blunt, Your Honor, yes, it's a tactical decision."
Tactical. Explicitly tactical. What was the tactic?
The prosecutor spelled it out. They explained that if the Crown tendered the MROI, then those exculpatory parts Singh's denial of involvement, Nguyen's explanations would become evidence for the jury to consider under the UEA without the defendants having to testify and face cross-examination on those statements.
Ah, I see. So by withholding the interview.
By withholding it, they put the defense in a bind. The defendant now faced a really tough choice. Either get in the witness box, tell your story, but face potentially damaging cross-examination, especially risky if there are communication issues.
Yeah.
Or stay silent, exercise your right not to testify, but then the jury never hears your explanation directly from that initial police interview, the one recorded close to the time of the event.
So the prosecution gets to present the damaging admission maybe through other means, but keep the potentially helpful explanation out unless the defendant takes the stand.
That was the tactic. And the same approach was confirmed for Mr. Nguyen's case, too. It was a deliberate strategy to strengthen the Crown case by limiting the defense's ability to get favorable evidence out easily.
That feels uncomfortable. Less about presenting all the facts and more about maneuvering for a conviction.
That's exactly how the defense saw it. Defense counsel protested strongly to the trial judge. They argued this was fundamentally unfair.
How did the trial judge rule on this? Could they force the Crown to play the interview?
The trial judge made two key rulings. First, they said they couldn't compel the Crown to tender the MROI. They upheld the general principle that the prosecution decides what evidence forms its case.
Okay, so the Crown couldn't be forced. What about the defense? Could they just introduce the interview themselves, say, when cross-examining the police officer who took it?
That was the second crucial ruling. The judge refused the defense application to tender the entire MROI during cross-examination. The judge relied on the prevailing view in some state courts at the time, ruling that exculpatory statements were generally only admissible as context for admissions already led by the Crown.
So, because the Crown chose not to lead the admissions from the interview, the defense couldn't use that as a hook to get the whole interview, including the exculpatory bits, admitted as evidence of their truth.
Exactly. The trial judge's rulings effectively locked the MROI out unless the Crown chose to use it or the defendant testified. It crystallized the central legal problem. Was the prosecution obliged by fairness to tender this admissible mixed statement, even if parts of it didn't help their case?
And the specific question was so important, especially for Mr. Nguyen, whose retrial hadn't started, that it got bumped up to a higher court.
Yes. Given the significance, two precise questions were formally referred from Mr. Nguyen's case to the full court of the Supreme Court of the Northern Territory, the NT Court of Criminal Appeal.
What were those two questions again, just to be clear?
First, is the recorded interview admissible in the Crown case? And second, the big one, is the Crown obliged to tender the recorded interview?
Okay, let's look at that NT full court decision. It's cited as Singh v. the Queen 2019 NTCCA 8. Who was on the bench and what did they decide?
The bench was Justice Kelly, Justice Barr, and Justice Blockland. On the first question, admissibility, they were all on the same page.
Yes.
Yes, the interview was admissible in the Crown case. Because it contained admissions, it clearly fell under Section 81 of the UEA. No real argument there.
But the second question, the obligation, that was the contentious one.
That's where they split, at least in the formal outcome. The majority, Justices Kelly and Barr, answered no to the obligation question.
No obligation on the Crown to tender it.
Correct. They found no general rule or principle that the duty of fairness requires the prosecution to tender a record of interview, simply because it contains admissible material.
What reasoning did they give for that?
They relied heavily on precedent from state-level courts in Australia, cases like Melton, Callahan, Azafiri v. Horn, Berry v. Police. These cases generally supported the idea that prosecutors have discretion and aren't forced to tender mixed statements, especially if they choose not to rely on the admissions contained within them. The underlying idea seemed to be that exculpatory parts are mainly just context for admissions the Crown chooses to lead.
So the majority view was Crown discretion rules. If they don't want to use the admission from the MROI, they don't have to tender the whole thing just to let the defense benefit from the explanation.
That was the effect of their formal answer.
Hmm.
However, Justice Blockland wrote a separate judgment. While she felt technically bound by the majority's answer to the formal question based on the existing authorities cited,
She had reservations.
big reservations, she expressed significant concern about the fairness of the situation, particularly how it looked, the perception of fairness.
What specifically worried her?
She pointed right at Mr. Nguyen's situation, his understanding when he gave the interview that it would be used, and she highlighted the prosecutor's own admission. It's a tactical decision.
To make the Crown case stronger.
Exactly. Justice Blockland felt this undermined the whole process, especially for someone potentially vulnerable like Mr. Nguyen. While she couldn't find a binding legal rule forcing the Crown to tender based on the precedents, she strongly suggested the prosecutor should rethink their decision in the interests of fairness.
It sounds like she was grappling with that core tension, the strict legal rule versus the spirit of justice.
Absolutely. And that tension, highlighted by her judgment, between the formal position based on state cases and the fundamental principles of fairness, especially given the prosecutor's admitted tactic and the defendant's circumstances, that made this case almost inevitable for the High Court.
It also suggested maybe the NT Court's view wasn't entirely aligned with how some interpreted earlier High Court hints about prosecutorial duties in cases like Soma and Mahmood.
That's right. It set the stage perfectly for the ultimate appeal.
So, Mr. Singh and Mr. Nguyen took their fight to the High Court of Australia. They appealed the NT full court's decision, zeroing in on that crucial no answer to the obligation question. The High Court heard both their cases together.
And this is where the arguments really got distilled. You had the core legal principles of prosecutorial duty clashing head-on with the practicalities of trials, communication barriers, and fairness. Let's talk about who was arguing these points before the High Court judges.
Okay, who were the key legal teams?
For the appellants, Mr. Singh was represented by barristers Ambrith Abhayasakara and Ian Reid. Mr. Nguyen's case was put forward by barrister Mr. Abbott.
And on the other side, representing the Crown, the NT Director of Public Prosecutions.
That was barrister Mr. Mortars.
Now, there was another significant voice in the courtroom, wasn't there? Not a direct party, but invited to assist.
Yes, a very important contribution came from the Northern Australian Aboriginal Justice Agency, NAJ. They appeared as amicus curiae, a friend of the court, represented by Philip Bolton SC, Marty Ost, and Julian R. Murphy.
What does an amicus curiae actually do in a case like this?
Their role is to offer a perspective or expertise that the court might not otherwise get from the parties directly involved. Here, NAJ was there to specifically address the implications of the prosecutor's duty when dealing with police interviews involving defendants who might have particular vulnerabilities, social, cultural, linguistic, physical characteristics.
This brings that human element, those potential disadvantages we talked about earlier, right into the center of the High Court's consideration.
Absolutely. NAJ brought their deep practical experience, 47 years, working with Indigenous people in the NT justice system. They highlighted things like communication barriers, maybe misunderstanding complex questions, the issue of gratuitous concurrence, where someone agrees just to be polite or move things along, not because they truly understand or agree.
Difficulty with the question-answer format versus maybe a more narrative way of explaining things?
Exactly. Or the impact of things like hearing impairment, which can be mistaken for sullenness or guilt. They painted a vivid picture of how these factors can dramatically affect an interview and how it might be perceived later.
And their argument was that these vulnerabilities make that initial police interview, the MROI, even more critical.
Precisely. They argued that the defendant's very first response, when confronted with the allegations captured in that MROI, is incredibly significant evidence. And fairness dictates it should normally go before the jury.
Because withholding it could exploit those vulnerabilities.
That was their point. Tactically withholding the MROI makes it much harder for a potentially disadvantaged person to get their explanation heard without facing the ordeal and risks of testifying at trial, where those same communication issues might be amplified under the pressure of cross-examination.
Did they mention the police caution aspect too?
They did. They linked it back, saying the caution creates an expectation this will be used in court. Withholding the interview, especially for tactical reasons when the person is vulnerable, breaks that trust and damages the fairness and the appearance of fairness of the whole process. It was a really powerful, context-rich submission.
Okay, so that was the crucial input from Naja. What were the core legal arguments from the appellants themselves, from Mr. Singh's and Mr. Nguyen's lawyers?
They built on the fact that the MROI was clearly admissible under the UEA. Their main argument rested on the fundamental duty of the prosecutor, not just an ordinary lawyer, but a minister of justice.
Meaning?
Meaning their job isn't just to win, but to ensure a fair trial and present the whole truth. They drew on major high court precedents, Richardson, Whitehorn, Apostolides, Mahmood, Soma, arguing this duty creates a prima facie obligation, meaning a default requirement, to tender all relevant admissible evidence. And that includes admissible MROIs with admissions.
And the prosecutor's reason for not tendering it, the tactical reason.
They hit that hard. They argued that a purely tactical decision, designed just to make the Crown's case stronger or to block the defense from getting the explanation out without testimony, that is not a proper reason for a minister of justice to withhold relevant evidence. They called it impermissible picking and choosing.
Undermining the prosecutor's role.
Yes, and they also raised the public interest point. People are encouraged to cooperate with police. That relies on an expectation that their account, good or bad, will be presented fairly. Tactical withholding undermines that cooperation.
So a strong push from the appellants and NAA Fairness demands the MROI be tendered. How did the Crown respond? What were Mr. Mortar's arguments for the respondent?
The Crown stuck to the position that there's no overarching legal obligation to tender MROIs just because they exist and are admissible. They emphasized prosecutorial discretion. The prosecutor decides what evidence makes up their case.
Including deciding not to use evidence they think is unreliable.
Yes, though the High Court later picked up on the basis for that assessment. The Crown argued they have discretion to decline unreliable evidence. They also leaned into the idea that exculpatory statements, because they're self-serving, are inherently less reliable than admissions.
And only really admissible as context.
That was part of their argument, echoing the traditional view in the NTCCA majority. They argued prior High Court cases didn't create a broad, positive duty to tender MROIs, suggesting those cases were about different issues, like not splitting the Crown case or cherry-picking within evidence already led.
And their answer to how the defendant gets their explanation out.
Their position was clear. The onus is on the defense to present an exculpatory case. And the proper way to do that, to get the explanation before the jury as evidence to be weighed for its truth, is for the accused to testify under oath, subject to cross-examination. Forcing the Crown to tender untested, self-serving statements, they argued, risked misleading the jury.
So it really came down to this fundamental clash. Prosecutorial discretion and strategy versus the duty of fairness and presenting all relevant evidence.
That was the absolute core of it. And the High Court had to resolve that clash, considering the modern evidence laws and the very real-world implications highlighted by NAJA and the appellants.
Which brings us to the decision itself. The High Court bench. Chief Justice Kiefel and Justices Bell, Gagler, Keene, Gordon, and Edelman. A full bench. What did they decide?
It was decisive.
Yeah.
Unanimous. All 7 judges agreed.
Wow. Unanimous. And the outcome?
The appeals by both Mr. Singh and Mr. Nguyen were allowed.
Allowed. So they overturned the Northern Territory Court's decision.
Yes. Specifically, they overturned the answer the NTCCA gave to that second question. The High Court held that, contrary to the NTCCA majority, the Crown is ordinarily obliged to tender an admissible mixed record of interview.
Ordinarily obliged. That's a very significant finding. What was the core reasoning behind that? How did they get there?
They started by really hammering home the fundamental role of the prosecutor. Not just an advocate, but a minister of justice. They have to act with fairness, with detachment, present the case fully and fairly, assisting the jury to find the truth, not just aiming for a conviction. They reference those key cases again, Richardson, Whitehorn.
Okay, establishing the baseline duty. How did they connect that to these mixed interviews?
They said that this core duty ordinarily requires the prosecution to tender all admissible evidence relevant to the issues in the trial. And they explicitly interpreted earlier high court cases like Mahmood and Soma as supporting this. An admissible MROI containing admissions relevant to the Crown case, but also explanations relevant to the defense. That falls squarely into this category of evidence the prosecutor generally must tender.
So it's not just any evidence. The MROI has a special status because it's often the defendant's first detailed response.
You could say that. It captures that initial account, and the court was crystal clear about the tactical reason for withholding it. This was absolutely critical.
What did they say about the tactical decision?
They said a decision not to tender, made purely for tactical advantage, to strengthen the Crown case, or to stop the defendant getting their explanation out without testifying, is not a legitimate reason. It's improper. It's inconsistent with the prosecutor's duty as a minister of justice. It amounts to that impermissible picking and choosing the appellants warned about.
That's a direct refutation of the Crown's main argument and the NTCCA majority view.
A very direct rejection in this context, yes. Now, the court did acknowledge there might be rare exceptions.
Like when?
They said there might be good reasons not to tender in exceptional circumstances. For example, if based on clear and objectively identifiable circumstances, the interview is considered plainly false or fanciful or plainly unreliable.
But not just because the prosecutor thinks it's unreliable.
No. Critically, they said a prosecutor's mere suspicion about the exculpatory parts or just wanting a forensic advantage, that's not enough. The reason has to be objective and substantial.
Did they comment on Mr. Nguyen's specific situation, his understanding of the caution?
They did. They specifically noted his understanding that the interview would be used and observed that the prosecutor's tactical decision disadvantaged him and wasn't consistent with their obligations. So the specific facts clearly mattered in applying the principle.
And the Crown's concern about misleading the jury with untested statements, how did the High Court deal with that?
They put the focus back on the jury and the trial judge. They said it's the jury's job to weigh all the admissible evidence, including the exculpatory bits of the MRI. Juries do this all the time.
They can handle it.
Yes. And the trial judge is there to guide them. The judge can give directions explaining how to approach statements not made under oath, how they differ from trial testimony. It's a standard judicial function. Trust the process, essentially.
So the message was, get the admissible interview in front of the jury and let the system work. Trust the jury, guided by the judge, to figure out what weight to give it.
That's the essence, yes. Put the whole admissible picture before them when it comes to these mixed interviews containing admissions. So appeals allowed, NTCCA orders set aside.
And what did that mean practically for Mr. Nguyen and Mr. Singh?
It meant that in their retrials or any further proceedings on these charges, the Crown was now required to tender those admissible MROIs. Unless, of course, they could demonstrate one of those rare, objective, non-tactical reasons not to.
So their explanations, given back then in the police station, would finally be heard by the jury as part of the evidence?
Yes. It didn't guarantee any particular outcome for them. Obviously, acquittal wasn't automatic, but it meant their full initial account formed part of the evidence puzzle the jury had to solve. It leveled the playing field significantly on that front.
But the impact wasn't just limited to these two cases, right? This decision sent ripples through the entire Australian legal system.
Oh, absolutely. Nguyen and Singh is genuinely a landmark decision. It provided much-needed clarity from the highest court. Before this, as the NTCCA decision showed, there was definitely some inconsistency across different states and territories on how prosecutors should handle MROIs.
So it settled those conflicting approaches.
It did. It laid down a clear, unified principle based on high court authority. And fundamentally, it powerfully reinforced that core duty of fairness for prosecutors. They aren't just partisan advocates. They have a higher duty to justice.
How has it changed things on the ground for prosecutors, for defense lawyers, day to day?
For prosecutors, the big change is the default position. They can no longer just tactically decide to withhold an admissible MROI containing admissions because it might help the defense. The starting point now is, if it's admissible and contains admissions, it goes in the Crown case.
And if they don't want to tender it?
The onus is now squarely on them to justify that decision based on those objective, non-tactical reasons. The High Court mentioned clear unreliability, not just suspicion or strategy. It flips the script.
That's a major shift in perspective and practice.
It really is. And for defense lawyers, it's obviously a very positive development. It means their client's initial explanation, the one given close to the event, is far more likely to get before the jury as actual evidence. They're less likely to be forced into that difficult decision about whether the accused has to testify just to get their story out.
And this seems especially crucial for those potentially vulnerable defendants that Najo spoke so powerfully about.
Without a doubt. The outcome strongly supports the need for fairness for people facing communication hurdles or other disadvantages. Their initial account, even if imperfectly expressed, is less likely now to be strategically buried. It helps ensure the jury gets a fuller picture from the start, regardless of how well the defendant might cope with testifying under pressure later on.
So the MROI, instead of being seen sometimes as a potential weapon to be selectively deployed, is now framed as essential evidence that belongs before the jury, assuming it meets the admissibility criteria.
That sums it up perfectly. It reinforces that the jury needs all the relevant, admissible pieces to do its job properly, not just the pieces that build the prosecution's narrative. It compels prosecutors to live up to that Minister of Justice title.
So let's recap this deep dive. We started with a nighttime robbery, which led to police interviews containing both admissions and explanations. Then, a critical tactical choice by the prosecution not to tender those interviews.
A choice challenged fiercely by the defense, leading through the NT courts, where the majority upheld the prosecutor's discretion.
That set up the High Court appeal, featuring powerful arguments about fairness, prosecutorial duty, and the specific challenges faced by vulnerable defendants, particularly highlighted by Nguyen.
Culminating in that unanimous High Court ruling, a landmark decision clarifying a fundamental principle of Australian criminal procedure.
The key takeaway: Australia's highest court declared that prosecutors, as ministers of justice, ordinarily must tender admissible mixed records of interview. Tactical advantage is not a valid reason to keep relevant evidence from the jury.
It reinforces the ideal of a fair trial, where the jury gets to hear the whole relevant story, or at least the whole admissible interview.
And connecting this back to you, our listeners, this case isn't just an abstract legal debate. It vividly shows how these principles directly impact real people caught in the justice system.
It demonstrates why the rules governing not just what evidence can be heard, but what evidence should be heard, are so vital for ensuring fairness, especially for those who might struggle to make their voice heard otherwise.
It really makes you think about the balance in our adversarial system.
It does. Which leads us to a final thought for you to ponder. If the goal is truth and fairness, and this case established that a defendant's early explanation in an interview is vital evidence the jury should hear, what other aspects of the trial process might need a closer look?
Especially concerning vulnerable individuals or complex evidence, are there other areas where procedural rules or tactical decisions might prevent relevant information from reaching the jury? How far does that duty to ensure a level playing field really extend for a minister of justice?
A crucial question, and one that continues to shape legal thinking and reform.